Steve is specialized in auto accident claims, has had three of the largest auto verdicts in the last 6 years, has spoken and is a member of the MTLA board. Areas of practice are auto negligence and no-fault insurance benefits. And Steve, you're going to talk to us about third-party litigation, practical issues from the plaintiff's perspective.
Next month, I'm going to be in Phoenix, and I'm going to be there with basically lawyers from all over the United States who handle trucking cases. And we're going to lock ourselves into a room for about 2 days, and we're going to talk about ways to sue trucking companies and deposing safety directors and what have you. And at night, we'll go out and we'll have a beer. And they always pick on me because I'm from Michigan. And they think Michigan law is so funny. You know, what do you mean you have no punitive damages out there? What do you mean threshold? Bad faith law in Michigan is very limited. So they think Michigan law is just hysterical, and they always have a lot of fun making fun of me. But, and this is the key point I'm trying to make, even if we didn't have this threshold law, I would still try these cases exactly the same way. And I think when the Republican legislature gave us a statutory definition of serious impairment, they gave plaintiff attorneys a very powerful tool to persuade jurors. And let me tell you what I mean. The first prong, objective manifestation. I don't think you ever want to go to trial without something demonstrative or objective so the jury can point to it and they can look at it and they know why they're there and they know why the plaintiff is in pain. It takes it out of the realm of two lawyers arguing and competing doctors. You always want to find something objective, whether it's an X-ray, MRI, CT, bone scan, PET, SPECT, EEG strip, you name it. There's always something you can find that's objective. So the jury can look at it and they know, because most jurors do want to do the right thing, and they're just so scared that they're going to be fooled. And unfortunately, because of tort reform, I think they usually think that plaintiff lawyers are the ones who are going to fool them, and we know better. But it's very powerful to explain to the jury why we're here. The second point, important body function. Sonia Hamlin, who I consider one of the top juror consultants in America, says this is the key to winning plaintiff cases. You have to explain to the jury what's normal, how it works, how it's supposed to work, before you can explain to them how it's broken. In other words, you have to explain what's normal before they can really understand what's abnormal. And we do a terrible job teaching our jurors why the plaintiff's injury is important. But you know what? If you're going to ask a jury to give you $1 million for a back injury or a brain injury, they better understand why it's important. And the third thing, how it affects their ability to lead their normal life, the third prong of our statute. You know, this is what plaintiff lawyers always struggle with, isn't it? How do you show pain? How do you make pain real? And it's hard, because pain is intangible. It doesn't mean anything. If I say the word hammer, all of you picture a hammer. If I say the word pain, nothing comes to mind. Or what's even worse, each of you might be thinking of a different thing in terms of what pain means. So how do you make pain real? You make it real by showing how the plaintiff's life is impaired, how the pain has changed, how it's altered, how it's affected the plaintiff's life between before the accident and after the accident. And the more ways you can do that, the more ways you are actually fleshing out what pain is, what the injury is. And it makes the plaintiff likable, and it makes the plaintiff worthy of help when the jury understands all the different ways that the plaintiff's life is impaired. Combined with the plaintiff IME, I think a very potent 1-2 combination that really plaintiff lawyers do not take enough advantage of is using the medical literature. You know, the Supreme Court has said that the factors the courts are to consider include the duration of impairment, the extent of residual impairment, the prognosis for recovery. And in these areas, the medical literature is very strong and it's very supportive for the plaintiff bar. Much of the peer-reviewed, published literature really talks about the long-term consequences and sequelae of very common injuries that we see every day in automobile accidents. When the Supreme Court says that judges are to look at the extent of residual impairment, at prognosis for recovery, you can use the published peer-reviewed literature to help you. In traumatic brain injury, when you have a mild traumatic brain injury, you can use the published peer-reviewed literature to talk about how the plaintiff's likelihood of getting Parkinson's or Alzheimer's or early onset dementia skyrockets. You can talk about the susceptibility of future injury and reserve brain capacity. If the plaintiff has a spouse and there's a consortium count, you can talk about the literature that shows the divorce rates, which are just staggering among the traumatic brain injured. If you have a bulging disc case, Dr. Chiodo from the University of Michigan has published 2 articles in the past 2 years that actually say that a bulging disc might cause more pain than a herniated disc. If you have a bulging disc, that becomes pretty important to your case. Every fracture case you have, you talk about traumatic arthritis. If you have a herniated disc, you talk about the susceptibility of the spine, about the increased pressure on the remaining spinal discs. If you have soft tissue, there are probably over 40 published peer-reviewed articles in important medical journals that talk about these being permanent injuries and very painful. And just as an aside, because I know we're now talking about the resurrection of Cassidy and we're looking at Argenta, a couple of years back there was a very bright, ambitious plaintiff's attorney in Florida who, after about, I think, a 10-year fight going back and forth in the Court of Appeals, back down, up, down, actually was able to show through the new literature out there that thermography is valid and scientific. And I think that attorney got almost $1 million in attorney fees doing it, so maybe one of you will take up thermography again. We'll see. I personally have a group of about 20 or 30 doctors and lawyers, and we just email each other back and forth whenever we see an article that we think is very helpful. And really, it's very easy to do. If you have an hour tomorrow when you're watching football, you get on the internet, you get on MedSite or PubMed or any of the others, and just start putting in some of the injuries that you have. And it's amazing what you can find. If you're like George and you're afraid of the internet, you can hire a medical student for $20 an hour and they'll find it for you. But I guess the key point I want to make is this. As a plaintiff attorney, when you're talking about the common type of injuries that a lot of us deal with day to day, the published peer-reviewed literature really is on our side. And you can't assume that the treating doctors know it or the defense doctors are going to admit it. But I think it becomes very powerful when you combine the published literature with the plaintiff IME in terms of really allowing that doctor to make some very strong opinions about the future prognosis of your client's injuries.